course through unprecedented waters today. In a first-of-its-kind judgment, the top court granted Delhi Chief Minister Arvind Kejriwal interim bail so that he could canvass to his heart's content for his party over the ensuing phases of elections. There are 4 phases left, viewers, beginning Monday, and now Kejriwal can go out there and champion his party's prospects. Never in recent memory has such a ground been invoked by supplicants seeking relief from jail, and never in recent times has a court been so obliging. As a result of the relief, Kejriwal can now freely plot poll tactics and direct the campaign for his party. For the AAP, the relief to their Supremo couldn't have come at a more opportune time. Kejriwal is the only face from the AAP who enjoys pan-India appeal. The seats where AAP is slated to fight from in Punjab and Delhi are all slotted to come up for polls in the next few phases. While the Supreme Court pronounced its order, it also set some conditions. And there you have visuals coming in of Mr. Kejriwal being wheeled really out of Tihar prison. There, I think, is his convoy. He is exiting now. He's coming out of the prison gates and he is going to head to his residence. Of course, the Supreme Court has imposed some conditions, but it made some references, it made some observations, and of course, it talked a little bit about what he can do and what he couldn't. So let me take you through that. Kejriwal does not have any criminal antecedents. He's not a threat to society, said the court. Serious accusations against Kejriwal, but he has not been convicted as of now. Holistic and libertarian view justified in view of Lok Sabha elections. Grant of interim bail, not an expression of opinion on merits of the case. Very important. Supreme Court says the fact that we've given interim bail doesn't mean that we've decided on the merits of the case, doesn't mean that he's innocent in any which way. Kejriwal will not interact with any witnesses connected to the case. Kejriwal will not access or sign official files unless needed for the Lieutenant General's clearance. Kejriwal will not make comments about his role in the money laundering case. These are some of the stipulated conditions that have been imposed on Mr. Kejriwal. Now, many AAP leaders were convinced that Kejriwal would get bail, as the Supreme Court had set the stage a few days ago. The Supreme Court had said there are 2 or 3 issues. One, he is an elected chief minister. Elections are around the corner. These are extraordinary situations, and elections are held once in 5 years. It's not like harvesting season once every 6 months, unquote. Now, viewers, the Enforcement Directorate had vehemently opposed Kejriwal's bail, and to many it appeared that the investigative agency had made some well-considered and plausible points. One wonders why the Supreme Court made a special case out for Kejriwal. Nonetheless, Kejriwal also earns the ignominy of becoming the first to be let out on bail with a preordained date of surrender. This is what the Enforcement Directorate had said while opposing his bail. They said bail for campaigning would create a precedent for all unscrupulous politicians to commit crimes and avoid investigation under the garb of fighting elections. This would create 2 separate classes of ordinary people bound by the rule of law and politicians who can seek exemptions. Nearly 123 elections have taken place in the last 5 years, and if interim bail is granted for campaigning, then no politician can be arrested. Every politician at every level would argue that he or she is not let out on interim bail, they would suffer irreversible consequences. Such an approach would incentivize every criminal to become a politician and be in campaign mode while committing rampant offences. Numerous examples where politicians contested elections in judicial custody and some even won, but were never granted interim bail on this ground, which is of course electioneering and campaigning. For 6 months, the petitioner has cited one election or the other, be it state elections or Rajya Sabha elections, as the reason for not complying with the law. If the right to campaign is treated as a basis for the grant of interim bail, it would breach the principles of Article 14 for the reason that harvesting for a farmer would be an equally important factor as would a board meeting for a director of a company. These were some of the reasons. And, viewers, plain reading, they look plausible. But what astounds about today's verdict is that the courts thus far have taken a dim view of bail pleas, argued by jailed politicians. Here are the hard facts, viewers, and I always bring you close to the hard facts so that you can get closer to the truth. May 9th, 2013, the Supreme Court, the same court, denied Jagan Reddy bail. Though Jagan had not sought bail for electioneering, his party, the YSRCP, had accused the Congress of hatching a conspiracy to keep Jagan away from the campaign. The Supreme Court then observed, economic offences constitute a class apart and need to be visited with a different approach in the matter of bail, unquote. Today, of course, viewers, it has applied a totally different yardstick. October 2014, Karnataka High Court, while denying bail to J. Jayalalitha, corruption, it said, is a human rights violation. It leads to economic crisis. It undermines the health of the polity. This is not a fit case for suspension of sentence or grant of bail. Of course, she was convicted, viewers. October 2014, the High Court struck down bail to O.P. Chautala. The INLD chief and ex-Haryana Chief Minister O.P. Chautala surrendered after the Delhi High Court asked him to do so for misusing bail conditions by campaigning, electioneering for assembly polls in the state. So there, viewers, it said you cannot, when you're out on bail, you cannot campaign, you cannot electioneer. Here, of course, Kejriwal has got bail to do exactly the opposite, which is to electioneer. Strange, viewers, but it's a fact. February 8, 2002, Supreme Court refused to entertain Azam Khan's bail plea. The top court refused to entertain Samajwadi leader Azam Khan's plea seeking interim bail to participate in a campaign ahead of the upcoming UP Assembly elections. That matter is still pending, viewers, before the Supreme Court. Now, will Azam Khan get the bail? Based on today's order, expect the following to possibly invoke the same grounds to also secure relief. There is Hemant Soren, ex-Jharkhand Chief Minister. In fact, he was today denied bail on a technicality. But he's free to go back and now invoke Kejriwal's precedent. The Supreme Court junked the plea challenging grounds of arrest. Then there is K. Kavita, BRS leader, March 15th, arrested by ED in Delhi liquor case. She'll want to go back to Telangana. The election is on Monday. She'll say, why haven't I been given bail? And there are many other cases, viewers. Amritpal Singh, Waris Punjab De chief. He's also a candidate now. He'll say, look, I also need to go and campaign for my election. He was arrested under NSA, lodged in Dibrugarh jail in Assam. He's also moved High Court for temporary release to file the Lok Sabha nomination. He'll also knock on the Supreme Court doors and he'll say, look, I must also be given some sort of reprieve. So viewers, all of this has become quite a precedent. And let's open this up. Let's ask some questions. Let's ask some questions of our formidable array of lawyers this evening. We're also awaiting, of course, Mr. Salman Khurshid on the panel. Now, I want to begin with Jay Anant Dehadrai, who's an advocate, and Sumit Chandar. I want you to weigh in. Mr. Dehadrai, I want to ask you, do you believe that this particular order is sound in law or in jurisprudence? Forget law, jurisprudence.
Rahul, firstly, thank you for having me on your show. And I have to compliment you for your research being absolutely on point. I was listening very carefully when you narrated a list of recent precedents in which, the Supreme Court had not granted, in fact, bail to jailed politicians. But there are two things that stand out for me. One, at least, this Khan Market gang and their lawyers, at least they can't anymore complain and say that, the Supreme Court has been taken over by this government, or that, they don't pass orders, or they pass orders that are only convenient to this government. At least that aspect is now firmly out. The second aspect, which is in terms of whether the bail granted today was right or not, I completely agree with you. Frankly, this is, and with great respect to the honorable judges, but I disagree with the reasoning of the court entirely. This was a great opportunity for the Supreme Court to lay down the law and say that be you ever so high, the law is still higher than you, is still above you. And you could be a politician, you could be a sitting chief minister, you could be anybody for that matter. But you had to see, the scathing observations in the High Court order in which Mr. Kejriwal had basically challenged the legality of his arrest. And it's a beautifully reasoned judgment in which it's absolutely clear that this man was the kingpin in this horrible corruption scandal. They were basically ripping off the state exchequer of Delhi and those plans were hatched inside Mr. Kejriwal's official home. So why is it, therefore, that this man is more special than, as you rightly pointed out, a person who has to look after his farm or a person who has to attend a board meeting? Why is it that the Supreme Court considers him more important or, worthy of getting interim bail? And one last thing, interim bail is not abnormal. It is certainly within, it is the prerogative of the court to grant interim bail because it's not a decision on merits. But interim bail is something that you grant to a person when they're extremely unwell, or there's a family member that's dying or extremely unwell, needs treatment, or there's something very pressing that's going to happen. But none of those circumstances existed in this case. So I'm disappointed. I'm very disappointed in the Supreme Court today.
Let me bring in Mr. Sumit Chandar. Mr. Chandar, equity under law. You had cases, I've recounted some of those, INLD chief, ex-Haryana chief minister O.P. Chautala ordered to go back because he, quote, misused the bail provisions to electioneer. Now you have the exact opposite here. How does this work? I mean, is there some sort of am I missing something? Is Mr. Kejriwal getting khas precedents because he's also now khas? What's happening here? Please explain, please illuminate us. I'm completely befuddled. And what if Amritpal Singh, who's actually a candidate, Mr. Kejriwal is not a candidate. Tomorrow, Mr. Sisodia will say, look, even I need to be by Mr. Kejriwal's side because both of us have to actually, print the campaign material and distribute it physically, and it will harm my party's interests if I can't go from door to door handing out these great, pamphlets for our party. So can you also give me bail? I'm an integral part of the political strategy cell of the Aam Aadmi Party.
Rahul, one thing which you pointed out very well was that equity is something important that courts need to look into. Supreme Court, of course, has powers under Article 142 wherever it feels complete justice is required to be done, it does it. But here in case, why are we looking at equity in a very different manner? Equity is for all aspects. Equity is also from a point of view that till today, there was at the time of arrest, the police had taken so many months to investigate. They did not arrest it at that time. They did not even feel the need of an arrest at that time. So Supreme Court in its view was like, if you don't need him for so many months, so many days, why do you need him now?
And Mr. Chandar, how many summons did Mr. Kejriwal avoid, and what was the time span that he avoided 9 ED summons? Can you give me that figure, please?
If his arrest at that time would have been so important, then the arrest would have been made at a much earlier stage rather than giving him summons. And if ED can wait for
But did he not constantly approach the courts and get relief? Am I mistaken?
So one way to look at it, Rahul, is that he was ready to participate in the investigation. He was not running away. I'm giving you a very neutral court's point of view.
But Mr. Chandar, you would agree that he did not submit himself. If he was actually somebody who was willing to cooperate, then why did he ignore 9 summons? Was it 9 or was it 11? 9, I think, yes. 9 summons.
But those 9 summons also, he was under the threat, and rightly so, which finally got true, because his entire apprehension was, if I participate in the investigation, the moment I participate, he will be arrested, which is exactly what happened eventually. So I'm trying to now show you the Supreme Court felt equity in this matter was different because here is a sitting chief minister who was required to participate in the election proceedings.
Okay.
He given summons earlier. He is not avoiding the participation in the investigation. And
well, that's a matter of unfortunate debate. Let me just very quickly, those are the pictures of Mr. Kejriwal surrounded by all sorts of flags. He's just come on. Mr. Salman Khurshid is also here with us. Let's just boost that nat up on those pictures. Is he making a comment? Is he saying something? Let's just quickly go across. Okay, lots of crackers bursting. Mr. Salman Khurshid, obviously this is a defining moment politically for Mr. Kejriwal. He can now willfully go out there and say, look, I've defeated the dictatorship and I have managed to get myself out of the clutches of the Enforcement Directorate, and look, this is a big victory for the truth, and so on and so forth. And the AAP has actually come out and said so. So I presume he's going to echo all of that. But I just want to ask you, many people are struck by the arbitrariness, quote unquote, arbitrariness of what the Supreme Court has done. Do you share this view?
Well, it's sorry, very difficult to comment on something like this, an order passed by the Supreme Court, unless you know the fine print of that order and the circumstances in which it was given. What we get to see from the outside is a broad impression that one has, that here's a person who was not well, here's a person who is important for the campaign in Delhi, and the court may have put this democratic issue up front and decided that this is only interim bail and we can grant him interim bail. In whichever manner he may receive it, he may articulate it, etc. I'm not sure that there's very much for us to comment. But obviously, since he's part of the alliance, we are all relieved and pleased and happy that he will be available for the campaign. But he has to face to the matter once again. He has to face up to the matter once again after 22 days, because I believe the order is for 22 days. And he will then have to convince the court again that he deserves permanent bail. So all that will come later. Right now, one can only say that there is a sense of relief and there's a sense of
True, that's a political point. But Mr. Khurshid, let me ask you, there is another individual and he has actually filed nomination papers. He is actually a candidate and he is lodged in Dibrugarh jail. His name is Amritpal Singh. We've all heard of him in a different context. He's allegedly a pro-Khalistan activist. Now, what if he tomorrow knocks on the doors and says, look, you've given this allowance to Mr. Kejriwal. He's not even fighting the election. He's instrumental to decide tactics and all that. Here, I am fighting the election and I need to come out. I thought that electioneering was not some fundamental right. Or now, does that change after the Supreme Court's precedent-setting interim bail?
No, it's not a fundamental right, but there are many factors that you take into account when you grant somebody interim bail or permanent bail. There are many factors that you look at. Sometimes you look at health. Sometimes you look at the nature of the offense that the person is accused of. Well, no. Electioneering is important. Electioneering is important. But I'm just saying that in granting bail, that is one factor. There could be other factors as well. There's the nature of offense that you're accused of, likelihood of flight, a responsible position that you hold, that you're not going to be accused of trying to get away from the law, etc., etc. But as I said to you right at the beginning, the details in the fine print of each case needs to be examined closely before one can comment that, there is parity, one person is campaigning, another person is not being allowed to campaign, etc. So that's very, very difficult to speak about.
I'll jog your memory back to October 2014. And this is an important matter because INLD chief and ex-Haryana Chief Minister O.P. Chautala, he surrendered. He was asked by the Delhi High Court to surrender because he was out on bail and he violated the provisions of bail by participating in an election campaign. Now, how does this case differ from Mr. Kejriwal? Wouldn't you say that Mr. Chautala in hindsight was punished?
No. You have to take the order as it comes. You can't speculate about why the order would have been given, why that order is different from any order given in another case.
Okay.
Because everything is argued in detail and the court takes into account whatever the court believes is relevant.
Okay.
And that would have happened, but you can research the matter and you can find that there is similarity, or you can find there's a distinction to be drawn.
So there's an element of discretion
here. But you can't in a pat comment.
There seems to be an element of discretion.
Bail is a matter of discretion.
That's right.
Please understand.
I understand.
There's certain
That's what
areas,
I'm saying.
there's certain areas of the law where discretion, judicial discretion, plays a very important role. And you can't sit in judgment over that. it has to be done by the judge himself. And
but there's
quite
also
often
something
the
called
Supreme
bail
Court also,
jurisprudence.
Will not interfere.
There is also something called bail jurisprudence, and one gets the sense that perhaps the court should have stuck to bail jurisprudence, and I don't know if that has been the case in this matter. Now, just give me 30 seconds.
Bail jurisprudence. See,
Yeah.
there are periods in which the court turns to bail jurisprudence with greater vigor. There are periods in which the court becomes a little conservative.
Right.
Now, over the last 10 years, there have been both movements, particularly because of the legislation like PMLA and so on, where the bail jurisprudence has been bypassed and a new jurisprudence has been introduced. So that's a lot to do with interaction between the legislation and the adjudication that the courts do. But you can't say that there is one size that fits all.
Okay. Now, let me open this up further. I want to bring in Ishkaran Bhandari. There's also Dr. Ranganathan there with us. Now, Ishkaran Bhandari, how do you look upon some of the arguments that have been forwarded by Mr. Khurshid on the matter that we have to judge every case individually, that there is element of discretion, which there of course is. Has this discretion sort of applied in consonance with jurisprudence?
Rahul, in India, 1 week we have dictatorship, another week we have democracy. So let's take this Arvind Kejriwal case only. On 21st March, we had dictatorship because the Honorable High Court refused to give interim protection from arrest to Mr. Kejriwal. And we saw that narrative and we saw how they were talking about the judiciary in the most unfortunate terms. And then today, because there has been an interim order, there is democracy which has suddenly come alive. And on 2nd June, when he may have to go and surrender again, we will again probably be living in a dictatorship. So let's move away from these political arguments and deal with it as a case. See, in this case, the Honorable Supreme Court itself records that Mr. Kejriwal did not attend 9 summons. Our friend on the panel said that why did the investigative agencies not arrest him then and there? If he had been arrested on the first summon itself, they would have said there is no evidence. They were acting in a haste. They wanted to arrest him. So you give person summons, you give him a chance to join investigation, to put forward his case, to be able to rebut the allegations against him. Now that becomes something against the ED, that why did they not arrest him on day 1? That is turning the thing on its head because they were giving him adequate time to answer. He did not respond to 9 summons. In my mind, I do not know of any other accused except another CM, Mr. Hemant Soren of Jharkhand, who did not respond to multiple summons. Otherwise, after 1 or 2 summons, the investigative agency, be it ED, be it CBI or be it local police, will immediately go for your arrest. In this case, what seems to have weighed and what seems to have weighed very heavily is election is happening. But that raises troubling question because who is an important politician? Is Mr. Kejriwal a politician of supreme importance? What about a minister in a state? What about somebody who is a cabinet minister, he is accused of an offense? How will you define a politician's relative importance? That's point number 1. The second aspect is how can you put politician in a category and as if his work is somehow so much more important than anybody else's work, because getting bail or interim bail in matter like this, effectively he's a professional politician. He has been given interim bail for whatever is his work and it is a very important part of his work right now because election is happening. But other people also have very important work. How will you differentiate between those people? So a lot of questions have been raised in this, except just one question, that is that our courts are functioning very independently and are passing orders very independently, and I hope everybody accepts that, and next time they don't get an order in their favor, be it Ram Mandir or be it Mr. Manish Sisodia's bail being denied, please do not cast aspersions on the judiciary then.
Well, let me bring in Dr. Ranganathan. Dr. Ranganathan, you were in trouble a little while back for contempt and all of that. Now, I suggest that you should file a large number of nomination papers all across the country. Next time you get a knock on your door and they say, we're coming to arrest you, just say, look, I have an election to contest and, or, to electioneer for my one-man party. So I think you'll definitely be given the benefit of doubt. Would you not, Doctor?
Good evening, Rahul, and good evening to my fellow panelists, all exalted lawyers, I might add, so I am the odd one out. But in the fact that I love dogs and I hate dog stealers, I have something in common with one of your panelists. But, if I were to form a party, Rahul, the problem is even my family members won't vote for me. So there's an exception there. But, this is a very serious matter. And as someone who's not from this amazing domain of law, but it interests me immensely. I have 3 or 4 points to make. Number one, Rahul, all men are equal, but clearly some are more equal than others. And the irony is that those who call themselves as Aam Aadmi are more equal than others. Personally, I find this judgment, although I respect the verdict of the Supreme Court, I find it very troubling on the following counts. Number one, you see, law, I used to think, like science, works on precedents. What is good for the goose is good for the gandu. So the point of the matter out here is, if as some of the excellent evidences that you brought from the past are true, then clearly the Supreme Court has rejected its own decision on those things, especially on Mr. Chautala, who it castigated for canvassing. And out here, a politician has been given bail for exactly that purpose. You talked about Jagan, you talked about various other cases.
Azam Khan.
So clearly, Azam Khan, clearly the Supreme Court is not working on precedents. Number two, as far as the fact that it is a very important job that Mr. Kejriwal is doing and he should be allowed to do it. Well, in 2020, the Supreme Court and in fact the High Court denied bail to a doctor. Now, is it a case of the Supreme Court that a neurosurgeon's job is less important, saving lives is less important than canvassing? If that is the case, then let Supreme Court say this, that some jobs are more equal or more important than others. But the most disturbing thing is, Rahul, in a couple of years ago, when ED changed its clauses and people complained that they were draconian, the matter went to the Supreme Court. A 3-judge bench heard it. And it actually sided with the ED and all the so-called draconian clauses. It said the reverse burden of proof was to stay. The property is to be attached. You don't need to give evidence according to ECIF. And most importantly, it said that the money laundering is to be equated and is to be as heinous as terrorism. This is what the Supreme Court said. Now, tomorrow, if Amrit Pal Singh or some other terrorist wants to stand for election, he says, well, I want to be given bail to be allowed to canvass. The Supreme Court will say, well, we've given, bail to Arvind Kejriwal. This person also should be allowed to be given bail. But I want to ask a legitimate question. If in Supreme Court's own words, money laundering, a serious case of money laundering is as heinous as terrorism, has the Supreme Court not erred out here? But I leave it to the other exalted lawyers on the panel to deliberate on this.
Yeah, Mr. Khurshid, precedent then must be applied. Can it be applied equally going forward to Hemant Soren's case or Amrit Pal Singh's case?
Let me just be clear. Precedent is important. What is called stare decisis is important. Decisions taken in one case have to be applied consistently in other cases as well. But it's only when you analyze the exact facts of each case that you can tell whether there was a ground for a distinction or not. And the court will always try to help the layperson in informing the layperson as to why a distinction is made. But you can't just simply say once you've given bail to one person, everybody else. There is an issue of parity.
Okay.
The court does take that into account, but sometimes parity, you get bail, sometimes you don't. Now, the events that happened in Jamia Millia and NRCCAA, and those 4 to 5 people who were granted bail by the High Court, the Supreme Court said that the long judgment on the UAPA was uncalled for at the initial stage of granting of bail, and therefore they said this case must not be applied to future cases. But nevertheless, the Supreme Court then refused to reverse the bail order, and that bail order, the Supreme Court further said, could also serve as a parity issue with other people applying for bail.
Okay.
And yet, just today, I have had a similar parity case rejected by the Supreme Court.
That's right.
Because you can't make it into a very, very narrow bind.
Okay.
It's the totality of circumstances that the court takes into account,
Okay.
and then decides whether this is a parity
30
case
seconds.
or this is a
Dr.
case that is
Ranganathan
different.
raising his hand. 30 seconds. Mr. Dehadra, yes, 30 seconds each, please. Yes, please. Yeah.
Absolutely, what Mr. Khurshid says is watertight. The discretionary order of the judges do stay, although I find it very disturbing that based on the judge's discretion, you can give an order which is at variance with a high court judge. So the two judges are giving different orders.
Yeah.
And also I find it very disturbing that when the Supreme Court denied bail to the Coimbatore bombers, saying that these guys had killed 56 people, the state government of Tamil Nadu let them out.
Absolutely.
Saying
Well, that's happened in other, yes, that's happened. Yes, very quickly, Mr. Dehadrai.
Thanks, Al. Just a very quick point to make. I don't disagree with Mr. Khurshid when he says that, bail, of course, is the discretion that is available, to the court and to a judge. But, in this particular case, there is no mystery. In paragraph 15 of the judgment, they've specifically stated that it's because elections are going
That's
on
right.
and the general election is on, which is why we're granting bail.
Exactly.
So now, to my mind, it's exactly what Mr. Ranganathan, Dr. Ranganathan also said very rightly. That how is it that, therefore, how is Mr. Kejriwal's work in such a situation more important?
Precisely.
Yes, he's a politician.
In fact, I found
but
it
I'm
very
sorry,
disturbing that the Supreme
but-
Court in its last hearing came out, and I found it very patronizing when they said, it's not harvesting season,
That's
which
right.
comes every,
No, but
6
in fact,
months.
it's much worse.
It's much
in fact,
worse.
This case is much worse because money laundering happens
Exactly.
subsequent to an offense,
Yes,
Rahul. So
yes.
the predicate offense here is corruption. There was
Well,
bribery.
allegedly,
And
yes.
Well, allegedly, of
Yeah,
course. And,
yeah.
and that is what the predicate case here is, that
Yeah.
money that was meant to go to the Delhi State Exchequer
Yes.
was
That's right. Look, we're not getting
siphoned-
into the
siphoned
merits.
away.
The merits no one has gone into. But yes, you're right. It was given for a very specific reason, which was electioneering, and it has not happened in the past, viewers. So the Supreme Court here, uncharted territory, and people will say exactly the same. I'm criminal, but I'm also fighting an election. I advise Dr. Ranganathan to go and file nominations all across the country. No problems. You'll never get into trouble. I'll take a short break. When we come back, Mahesh Jethmalani on the larger question and the political face-off, viewers. Don't go away.
Aadmi Party will use to its advantage. What's the latest? What are you hearing from the Supreme Court, and what exactly has led to the Supreme Court finally overlooking the Enforcement Directorate's objection and granting interim bail to Arvind Kejriwal?
Well, definitely, this is definitely a big order that has come to the fore, and a massive relief for the Enforcement Directorate, and a massive relief for the Delhi Chief Minister, and a big setback for the Enforcement Directorate. I'll take that question across to Ananya now. Ananya, what made the court decide that Arvind Kejriwal should be granted an interim relief in this entire matter? Because this is first of a kind that has happened, and what could be the repercussions of such an order on future cases?
Well, definitely, this is a big order coming in from, in fact, the Supreme Court bench headed by Justice Sanjeev Khanna and Dipankar Datta. As soon as they said that, they are granting interim bail to the Delhi Chief Minister in this particular case. And in fact, when the Enforcement Directorate raised a claim that, he should not make any kind of a statement, the court had a very strong observation to make that, whenever such statements are being made, the Enforcement Directorate too is countering them with stronger statements, is what, in fact, the Justice Khanna said in a lighter vein. But at this particular point of time,
मौखिक ऑर्डर कोर्ट ने प्रोनाउंस किया। उसमें कोर्ट ने कहा कि अरविंद केजरीवाल जी को 20 दिन के लिए इंटरिम बेल दी जा रही है 2 जून तक, और कोई कैंपेनिंग के ऊपर कोई रिस्ट्रिक्शन नहीं है, वो क्या कह सकते हैं या क्या नहीं कह सकते हैं उस पर कोई रिस्ट्रिक्शन इम्पोज नहीं की गई है। जबकि जब ऑर्डर भी प्रोनाउंस किया जा रहा था तब भी ईडी ने रिक्वेस्ट किया कि कोई रिस्ट्रिक्शन डाली जाए, लेकिन कोई रिस्ट्रिक्शन नहीं दी गई है, और 2 जून को उन्हें 2 जून तक की ये मोहलत दी गई है इंटरिम बेल की। अब मैं अंग्रेजी में बोलता हूं। और अभी जितना ओरली बोला गया है, ओरली ऑर्डर में और कोई कंडीशन नहीं है, लेकिन हमें लिखित ऑर्डर देखना होगा कि और कोई कंडीशन है या नहीं है, पहली बात। दूसरी बात, इस ऑर्डर जब ये अपलोड हो जाएगा और अवेलेबल हो जाएगा, इसके बेसिस पे ट्रायल कोर्ट रिलीज का ऑर्डर पास करेगा। हम कोशिश करेंगे कि जल्द से जल्द आज ही हो जाए, वो हमारी कोशिश रहेगी कि अरविंद जी आज ही रिलीज हो जाए, वो जल्द से जल्द रिलीज हो जाए और आज ही रिलीज हो जाए। इंग्लिश में टुडे एट 2 PM the bench in court 2 assembled for this matter, and it pronounced a very short oral order. We have not yet seen the written order, which will be uploaded in the course of the day as we understand. And in that oral order, the court indicated that they are granting interim release / bail to Mr. Arvind Kejriwal, and that order of interim release will be operable up till 2nd of June, that is during the election process, and there is no restriction on his campaigning as to what he can say, what he cannot say while he is out in these 22 days.
Viewers, let's join Mr. Mahesh Jethmalani to understand today's Supreme Court interim order, Precedent Setting 1. Mr. Jethmalani, thank you very much for speaking to me. Your reaction to the unprecedented nature of the Supreme Court order today.
Right. The result doesn't matter, right? The final order doesn't matter, but the point of principle involved is important, right? To a large extent, Rahul, grant of bail and interim bail are matters of judicial discretion. It depends on the facts and circumstances of each case. But I want to quote Justice Krishna Iyer. It's very important. It's very well put. That there are limits to judicial discretion, right? And he actually, in a pretty old judgment, in the 70s, right? He quoted Justice Cardozo, Benjamin Cardozo, who's one of the legends of the American judiciary, on the subject. This is what he says: the judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his own ideal of beauty or of goodness. He is to draw his inspiration from, note these words, consecrated principles. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinated to the primordial necessity of order in social life. Okay? So, when you're dealing with a subject concerning in which you exercise judicial discretion, which is so much depends on the personality of the judge, you are still bound by principles of bail jurisprudence. Now, according to me, there is no discernible. As you said, that this is an unprecedented case. On the contrary, right, there are many cases, Lalu, Jayalalitha, etc., right, who have asked for bail during elections and they've been rejected. So the precedent is against it. Now, look, I'm all for bail being the rule, etc., etc. There's a presumption of innocence for Mr. Kejriwal, but there's an established precedent now, right? And bail must ultimately be decided on bail jurisprudence.
Okay.
And present bail jurisprudence doesn't envisage what the court has done. I mean, it's a great principle to invoke that, we are the largest democracy and elections are the lifeblood of democracy and all that. And that's all, undeniable.
Right.
The fact of the matter is, I personally, I'm not concerned about the end result. Right?
Okay, that I've understood. But I want to ask you, can judges disregard implications of the precedent they are setting?
Yeah, I mean, the Supreme Court will, if this happens, open itself to a criticism of being invidious, right? Which is not a good thing. They may have opened, the floodgates for these interim bail applications during elections, right? And as you know, elections in this country, right, happen every 3-4 months.
Yeah.
So why stop at one parliamentary election? The Supreme Court has laid great store by the fact that this is a once in a 5-year event. But that logic doesn't necessarily apply to people who say, look, I'm more concerned with, my state elections. I'm a state politician. So democracy is, elections, lifeblood of democracy indeed. But, they're perpetually in motion in India.
Yeah, and that's why I actually want us to look at
you get such pleas all the time.
Yeah, so I want us to look at this Chautala case. His bail was scrapped by the High Court because he misused the time for electioneering. And today we have the Supreme Court that's going the totally opposite direction How do we square this, Mr. Jethmalani?
So that's what I said. I mean, it's judicial discretion can sometimes lead to conflicting results, right? And then you have to decide which of the conflicting decisions are arbitrary or not. But the Chautala's case was a High Court judgment. This is a Supreme Court judgment. So the precedent is now this judgment.
Okay, so let me ask you, my last question, is the grant of interim bail a reflection on the Enforcement Directorate, or perhaps the fact that it doesn't have a case? Could you have argued the case better personally? Did they slip up in your opinion?
No, it's not a reflection on anybody. That's it. It's far be it from me to say that this was a faulty argument or an inadequate argument. But no, I think the judges had, probably given an indication, and it was very hard to overcome that. They seemed to be very impressed by the fact that, the 18th Lok Sabha elections are on, and Kejriwal being a chief minister, right? He needs to be heard. He needs to be heard by the public during the course of this election. He needs to exercise his right, and people need to hear it. That seems to be the sum and substance of the reason why discretion was exercised.
Dr. Ranganathan, yeah.
But and they've hedged it. To be fair to the judges, they've hedged it. They've said, look, he will not, act as chief minister. He will not sign any files. He will not discuss this case in public. He will not meet, witnesses in the case or have access to any of these case files. So there are sufficient safeguards of no misuse of this liberty. And one thing they should have put is that he should not meet his co-accused, Sisodia, and that I think is missing in that order. That he should also not meet during his period of 3 weeks of freedom, meet Sisodia and Sanjay Singh. That also should be there because they are co-accused in the matter.
Well, let me expand this. We're going to get Dr. Ranganathan also. Thank you, Mr. Jethmalani, for speaking to me. Let's open this up. Let's go across to an AAP supporter, Mr. Piyush Joshi. Mr. Joshi, I'm failing to understand why the AAP is going so gaga. I mean, why is it so excited today? Kejriwal is perhaps the first to be granted bail with a date of return set in advance. This is not a judgment exonerating him. This is a reprieve for a very limited purpose. Now, whether we agree with that or we don't, that's immaterial. He only has to go out there and campaign. There are several restrictions. He can't even behave like a chief minister. In fact, this looks more like an indictment, a reflection that the case is very strong.
Well, one can perceive it as an indictment, one can perceive it as an exoneration, but the fact of the matter remains that Mr. Kejriwal is out and he is available for campaigning purposes, and that is why each and every Aam Aadmi Party volunteer is basically elated and overjoyed because their supreme commander is out.
No, they are not just...
he will be...
Sorry, Mr. Joshi, it's not about that. What they are saying, to be very specific, is this is the defeat of dictatorship. How does this translate into the defeat of dictatorship?
Well, you have had an illustrious panel in the previous debate as well, and you had an elaborate legal opinion of Mr. Jethmalani. And I'm not a lawyer, but how do I see this judgment in my own limited capacity? I understand that this is a statement against the recent trend, which has been set that you can arrest the chief ministers, democratically duly elected chief ministers, just on presumptions, with very, very limited facts at your disposal. Just based on mere statements, you can keep the prominent leaders of opposition indefinitely in the jail. And that is why, if I perceive that judgment, as a statement against that kind of dictatorship, then
hang on, Mr. Joshi, hang on. Who's keeping whom in jail? Mr. Sisodia, for example, is being held in jail not because of the government. The government affected the arrest through the Enforcement Directorate. The Enforcement Directorate did its job. It is mandated by the Supreme Court to behave in a particular way. Those issues with regards to the Enforcement Directorate's untrammeled powers were challenged and upheld by the Supreme Court. The ED is not doing anything ultra-virus. And Mr. Sisodia from February last year is in jail, continues to be denied bail, not because of Mr. Modi, it's because of the courts themselves.
what the ED is doing is very clear, because the ED is basically acting as an extended arm of the Bharatiya Janata Party.
No, but that is all
Because
tested, you see, on the anvil of
Look,
the law.
Rahulji, kindly allow me to make my remark and then you can come in. I hardly speak for 10 to 15 seconds and you interject. And then you can give the opposite panelists all the time you want in the world. All I am saying that the ED rushed into the court and ED basically wanted the Aam Aadmi Party made a co-accused on the very same day that the Supreme Court pronounced its judgment. So, it is amazing to see that the Enforcement Directorate
But he has not been exonerated.
in a rush.
You do realize that,
Of course, he's
Mr.
not
Joshi.
exonerated. The exoneration will come in due course of time.
Okay, he's only been given.
that
Hang
will
on,
also
viewers.
come.
The ED didn't rush in anywhere. They sent him 9 summons over 6 months almost. Yes. 1 second.
How many summons did they send to
Kant.
Hemant Biswa Sharma? How many summons did they send to Hemant Biswa Sharma?
Mr. Pratyush Kant, quick response. How many summons were sent to the others that you have gratefully accepted into your party?
There is no case against Hemanta Biswa Sharma. These are all propaganda. There is no truth to it. But Rahul, the main issue here today is, after the Supreme Court giving him 21 days of bail, why is this chest thumping?
Okay.
Why is this giving bhashan like a hero? He's like an armed Kaidi who has come out on interim bail.
Okay.
Look at the kind of stringent point that has been laid out by the Supreme Court. You have to surrender your passport. You have to inform the agency if you go to the city.
Right.
You have to give your live location. You can't sign any file. You can't go to the CM office. You can't go to the secretariat. You can't do any bayanbaji on Sharab Ghotala. You have to give a 50,000 rupees bond. I mean, look at all these things. Do you think he's a hero? It is the strength
He's
of the
no
Indian
hero.
democracy.
Dr.
strength of the Indian
Ranganathan, the
constitution is out
BJP
on
says
bail.
he's no hero. In fact, the Aam Aadmi Party is now sort of suggesting that he's some sort of a hero. You saw Mr. Kejriwal there with his mic in hand and saying that I thank the Supreme Court. And remember that the AAP had called his arrest draconian. The SC says now go back to jail. It's not as if his arrest is just going to disappear. How do you see this, Doctor?
A couple of points here, Rahul. One, I would like to ask my good friend, Dr. Joshi. Yes, he may be correct in saying that the ED is at the beck and call of the government. Dr. Saab, is the High Court also at the beck and call of the government?
So can I respond? Of course not. The High Court has to adjudicate in accordance with the law of the land, and so does the Supreme Court.
Yeah, thank you. Thank you. So,
but
please,
which is
Dr. Saab, I didn't interrupt
the
you.
Supreme Court, Anandji? You asked me a question, so I am asking you to answer. Which is the higher court?
Because we don't have enough time, I didn't interrupt you. Thank you so much. Just a couple of submissions. One, yes, previous panelists correctly said, Rahul, rather disappointingly, I might add, that law is not science. So you have discretionary, benefits accrued to the judge. And the High Court judge, it's quite problematic that to his discretion, he denied the bail to Mr. Kejriwal, and the Supreme Court judge has said, no, I am giving bail to Mr. Kejriwal. You cited cases where the Supreme Court and other courts have hauled politicians for, election canvassing, which is exactly the reason why Kejriwal has been given bail by the courts now. So obviously, as I said, it is discretion. What can you do about it? You can't. But the fact of the matter is, can Dr. Joshi deny, or any AAP sympathizer deny, that the High Court, not the BJP government, not Modi, not ED, the High Court said that there is substantive evidence that Arvind Kejriwal used or coerced the proceeds of crime? Is it a fact or is it not? I ask a very simple question.
Well,
let Mr. Joshi say it is wrong.
Well, he won't, obviously. And let's give him...
It is only prima facie, and this is Akshay
prima
Tritiya,
facie, absolutely. Prima facie, there is evidence.
The truth is non-decadent, and the truth will remain Akshay no matter what happens. So happy Akshay Tritiya to each and every fellow citizen of my country, and happy Akshay
Remember, viewers,
to every Aam Aadmi Party supporter.
Remember, viewers, Justice Krishna Iyer came out and said there is also a limit to judicial discretion. So it's not as if you can do as you please. You don't have full remit. Anyhow, viewers, I'll leave it at this. It's been an absorbing half an hour, 45 minutes. We've gone into quite a few minutiae of the law, etc., etc. I hope you went away feeling a little more enriched and a little more aware of the facts. I'll leave it at this, viewers. We'll be right back with a special show, Citizens Manifesto, coming up with Anand Narsim.
Aspect, we'll have to see the order and then only comment.
So when do you think he'll be released?
We are anticipating that the order should be getting uploaded quickly. We'll obviously move for release today itself. We'll try for the release today itself, and we hope that it should happen today itself. Thank you.
Big relief for the Aam Aadmi Party. Interim bail has been granted to the Chief Minister Arvind Kejriwal. He will not be allowed to discharge his duties as the Chief Minister. This bail, in fact, has been given by the Supreme Court for him to campaign for his party and for the other party candidates as well. But a huge relief there for the Aam Aadmi Party. Now, they are going to use this. They were going to say that they stand vindicated. A massive relief coming in there for the Aam Aadmi Party and for the Chief Minister Arvind Kejriwal, who has been granted bail till the 1st of June. And as we've been telling you that all this while, the Enforcement Directorate had even filed an affidavit in the Supreme Court, raising very strong objections, appealing to the Supreme Court not to grant him interim bail, saying that if this is done, it would set a very wrong precedent. They even said that never in the history of elections has any politician be granted interim bail for campaigning. Ananya joins us now. Arunima is with us. All right, I'm getting a lot of information right now. Arunima, a huge relief and a big news coming in from the Supreme Court with Arvind Kejriwal being granted interim bail to the 1st of June. What else are you hearing from the court?
See, one thing that you have to underline is that Arvind Kejriwal is being granted bail not just till polling happens in Delhi, which is on the 25th, but also beyond that. So what the Supreme Court is conceding is that the Aam Aadmi Party is a national party, and as its convener, Arvind Kejriwal might have to campaign in the last 3 phases, and therefore he is being given that opportunity. Abhishek Manu Singhvi, representing Arvind Kejriwal, tried to argue that 4th of June is when the results are coming, so allow him to be on bail till then. But what Justice Sanjeev Khanna said is that campaigning ends 48 hours before that, and we are explicitly granting him bail so that he can go out and campaign. What is also being argued here, SG Raju is saying that you must underline that Arvind Kejriwal will not say anything about this case, to which Justice Khanna says, like in Sanjay Singh's matter, you are entitled to counter him with equally strong statements. 21 days here or there should not make a difference. He must not speak about the case and must surrender, is what Tushar Mehta says. And on 2nd, he will surrender, is the order coming in from Justice Khanna. All of this is being spoken about as we are saying. Ananya is reporting it from inside court.
Is the historic third-term dream achievable? Join me, Shapun Das Gupta, for the most dynamic and distinct coverage. Unrivaled political punditry and the sharpest election analysis. Elections equal CNN News 18.
Order. He's confirming now that bail has been granted till June 1st. On 2nd of June, Arvind Kejriwal will have to surrender. In the interim, he cannot discharge any duty as a chief minister. He cannot speak about this case. So during the course of the campaigning that happens, one will have to wait and see how the messaging by the Aam Aadmi Party is altered.
Yes.
Because their entire election campaign so far was on Arvind Kejriwal, his photo behind bars. Now that the court has granted him interim bail and put a bar on him from speaking on this particular case, how does that alter AAP's campaign is something that we have to wait and watch. But for now, AAP Karyakartas will be in a celebratory mode.
Absolutely.
Arvind Kejriwal is coming out of the jail for now, till June 1st.
Oh, absolutely. The Chief Minister, who was arrested by the Enforcement Directorate in the money laundering case, finally being granted interim bail. Big news coming in there from the Supreme Court, which had been mulling for quite some time, despite very serious objections being raised by the Enforcement Directorate, who went ahead and filed an affidavit raising strong opposition to the Supreme Court granting bail. But the Supreme Court now granting interim bail to the Chief Minister Arvind Kejriwal up till the 1st of June. Ananya joins us for more on this. Ananya, over to you. this is a big news coming in, a big development in politics and especially during the election season, something that the Aam Aadmi Party will use to its advantage. What's the latest? What are you hearing from the Supreme Court and what exactly has led to the Supreme Court finally overlooking the Enforcement Directorate's objection and granting interim bail to Arvind Kejriwal?
Well, definitely, this is definitely a big order that has come to the fore and a massive relief for the Enforcement Directorate and a massive relief for the Delhi Chief Minister and a big setback for the Enforcement Directorate. I'll take that question across to Ananya now. Ananya, what made the court decide that Arvind Kejriwal should be granted an interim relief in this entire matter? Because this is first of a kind that has happened, and what could be the repercussions of such an order on future cases?
Well, definitely, this is a big order coming in from, in fact, the Supreme Court bench headed by Justice Sanjeev Khanna and Dipankar Datta. As soon as they said that, they are granting interim bail to the Delhi Chief Minister in this particular case. And in fact, when the Enforcement Directorate raised a claim that, he should not make any kind of a statement, the court had a very strong observation to make that, whenever such statements are being made, the Enforcement Directorate too is countering them with stronger statements, is what, in fact, Justice Khanna said in a lighter vein. But at this particular point of time,
मौखिक ऑर्डर कोर्ट ने प्रोनाउंस किया, उसमें कोर्ट ने कहा कि अरविंद केजरीवाल जी को 20 दिन के लिए इंटरिम बेल दी जा रही है 2 जून तक, और कोई कैंपेनिंग के ऊपर कोई रिस्ट्रिक्शन नहीं है, वो क्या कह सकते हैं या क्या नहीं कह सकते हैं उस पर कोई रिस्ट्रिक्शन इम्पोज नहीं की गई है। जबकि जब ऑर्डर भी प्रोनाउंस किया जा रहा था तब भी ईडी ने रिक्वेस्ट किया कि कोई रिस्ट्रिक्शन डाली जाए, लेकिन कोई रिस्ट्रिक्शन नहीं दी गई है और 2 जून को उन्हें 2 जून तक की ये मोहलत दी गई है इंटरिम बेल की। अब मैं अंग्रेजी में बोलता आज से लागू होगी। और अभी जितना ओरली बोला गया है, ओरली ऑर्डर में और कोई कंडीशन नहीं है, लेकिन हमें लिखित ऑर्डर देखना होगा कि और कोई कंडीशन है या नहीं है, पहली बात। दूसरी बात, इस ऑर्डर जब ये अपलोड हो जाएगा और अवेलेबल हो जाएगा, इसके बेसिस पे ट्रायल कोर्ट रिलीज का ऑर्डर पास करेगा। हम कोशिश करेंगे कि जल्द से जल्द आज ही हो जाए, वो हमारी कोशिश रहेगी कि अरविंद जी आज ही रिलीज हो जाए, वो जल्द से जल्द रिलीज हो जाए और आज ही रिलीज हो जाए। इंग्लिश में बोल।
Will these elections impact Bharat's rise in the world? Join me, Nalin Mehta, for the most dynamic and distinctive coverage, unrivaled political punditry, and the sharpest election analysis. Elections equals CNN News 18.
Today at 2 p.m. the bench in court 2 assembled for this matter, and it pronounced a very short oral order. We have not yet seen the written order, which will be uploaded in the course of the day as we understand. And in that oral order, the court indicated that they are granting interim release / bail to Mr. Arvind Kejriwal, and that order of interim release will be operable up till 2nd of June, that is during the election process. And there is no restriction on his campaigning as to what he can say, what he cannot say while he is out in these 22 days. Any further aspect, we'll have to see the order and then only comment.
So when do you think he'll be released?
We are anticipating that the order should be getting uploaded quickly. We'll obviously move for release today itself. We'll try for the release today itself, and we hope that it should happen today itself. Thank you.
Big relief for the Aam Aadmi Party. Interim bail has been granted to the Chief Minister Arvind Kejriwal. He will not be allowed to discharge his duties as the Chief Minister. This bail, in fact, has been given by the Supreme Court for him to campaign for his party and for the other party candidates as well. But a huge relief there for the Aam Aadmi Party. Now, they are going to use this. They were going to say that they stand vindicated. A massive relief coming in there for the Aam Aadmi Party and for the Chief Minister Arvind Kejriwal, who has been granted bail till the 1st of June. And as we've been telling you that all this while, the Enforcement Directorate had even filed an affidavit in the Supreme Court, raising very strong objections, appealing to the Supreme Court not to grant him interim bail, saying that if this is done, it would set a very wrong precedent. They even said that never in the history of elections has any politician be granted interim bail for campaigning. Ananya joins us now. Arunima is with us. All right, I'm getting a lot of information right now. Arunima, a huge relief and a big news coming in from the Supreme Court with Arvind Kejriwal being granted interim bail to the 1st of June. What else are you hearing from the court?
See, one thing that you have to underline is that Arvind Kejriwal is being granted bail not just till polling happens in Delhi, which is on the 25th, but also beyond that. So what the Supreme Court is conceding is that the Aam Aadmi Party is a national party, and as its convener.
Namaste, Jai Hind, and welcome to the Citizens Manifesto, and we're coming to you from the Bandra Fort, ladies and gentlemen. We've had some political discussions heated at that, but this is about the citizens. Citizens of Mumbai, Amchi Mumbai as a lot of Mumbaikars would call it. It's the financial capital of Bharat. It's the capital of the state of Maharashtra, a state that returns 48 MPs, second largest contribution to the parliament after Uttar Pradesh, which sends 80 MPs. What are the issues in Maharashtra this time around? Does Mumbai reflect all of Maharashtra? No. But we've got individuals who've been seeing things evolve between 2019 to 2024. A lot has happened here in Mumbai too.